Can you hear me now?
Yes, sir. I'll record.
Very good. Let's start afresh. Why don't you say sooner if you can't hear me? So you allow me to record or you can record?
I
Quick.
record it, sir.
Okay. Well, so we're starting to discuss essential elements of contracts where we're talking about the fundamental and most essential aspects pertaining to contracts in general. Under specific varieties of contracts like sale and partnership and their types and varieties, there will be more details and requirements. How should the siga or expression be? What are the requirements? And what should the subject matter be? And what are the conditions and details? But at this stage, we are talking of the general requirements for all contracts. So therefore, we are looking at things in a very fundamental manner, applicable to all forms of contract. So from this perspective, we said that the essential elements for contracts in general are three, which are the contractors, the expression of contract, and the subject matter of contract. And we took up expression of contract first. And after looking at what expression is, we said that expression is the external indication provided through which the contractual intent of the parties is delineated or outlined. So without this external indication of contractual intent called the expression or siga, there cannot be a contract. In fact, when we say contract, we usually mean this expression of contract, the text of contract. You see? Although the contract is more than that, but usually when we say contract or aqd, we refer to this siga or text. Well, now, after looking at what expression is, what is the essential nature of expression is, we started to talk about modes of expression. What are modes of expression? Yes, the forms in which the contractual intent can be expressed or indicated, you see, which could, the indication provided by this external indication called expression can either be linguistic or customary. Linguistic means that according to rules of language and meanings provided by languages known to people, we come to know of the indication provided. You see, if they use the term sale, we know that this is the nature of the contractual legal effect the parties are creating. So through the indication provided by language and its meanings, we come to know of the nature of the contractual intent. That is linguistic, is the expression. And there can be customary expression as well, of which we shall discuss now under contracting through actual exchange. Well, so we talked about expressing contractual intent through writing, expressing contractual intent through the mode of verbal expression through speech, and we have to discuss about expressing contractual intent through the use of gestures or signs. Well, expression through the mode of signals or signs, you see, this also is an acceptable form of expression, acceptable mode for expressing contractual intent. So in this mode, the parties are not using speech or writing. The contractual intent is not indicated through spoken words. When words are spoken through the meanings that people know regarding those words in that language used, the people come to know, or the parties can understand, and others can understand the nature of the contractual intent. In writing too, the same language is used, although not in the spoken form. In written form, language is used. Now, in the use of gestures and signals too, it is a form of using language, but not spoken language or language comprising sounds and words and letters, rather agreed signals, agreed movements of the hands or any other part of the body, which has an understandable meaning, at least for the parties concerned, or at least for as well, or for others as well. These movements or signals are indicative of clear meanings. You see? So this is language too. You can call it sign language. You see? The sign language as non-universally or any other forms of signs agreed in that community or that locality or among those parties concerned. But these signs and signals do convey meanings. So it is a form of using language, although it is not language of sounds and letters. Well, so as long as these signals are meaningful, there is no bar to using this, because the purpose of expression is to indicate contractual intent. And if these signs and signals or gestures are successful in indicating meanings clearly, in that case they are acceptable. But we know that this language of signs and signals is not as common as the use of language comprising letters and words and sounds. So because of this, in the many schools of Islamic law, use of sign language is only permissible and allowed for creating contracts when the parties are not capable of using language as commonly used. You see? If a person is dumb, cannot speak, then he should use writing, because writing is universally, or at least to a large segment of people, the meaning is clear if written. If the person who may not speak, he cannot write also, then he is allowed to use sign language. The only reason being the limited scope of people who are aware of the meanings of these signs. So if the meanings are clear, even sign language can be an acceptable means for creating contracts. The question of preserving a record will of course arise. So for this purpose, if it is a contract that has long-term effects, such as a contract which involves credit, or usually involves a period such as a lease or a rent, or service, where the legal effects are not created and finalized and acquired and transferred there and then, in that case, they will need to have witnesses as well in order to resolve in dispute which could arise. But I said repeatedly, our purpose is to discuss creation of contract. So as far as creation of contract is concerned, as long as the signs are meaningful and convey the nature of the contractual legal effect created clearly, they can be accepted. Well, now we had looked at expressing contractual intent through verbal or spoken words or written words in writing, and also through the use of meaningful signals. Now there remains another situation where contracts are created through what is called action. And sometimes in some of the books, you may find this referred to as another mode. You see, speech, writing, gestures, and actions. Actions are straight away mentioned as a mode. But remember, when you say contracting through action, it is not similar to the use of bona fide modes, so proper modes such as speech, writing, or gestures. In speech, writing, and gestures, the parties intentionally provide an external indication or create an indication of their contractual intent. The parties speak out and say, this is the nature of the contract I'm creating. Or the write and say, this is the nature of the contract I'm creating. Or through sign language, they say, this is the nature of the contract I'm creating. Well, in contracting through action, in fact, the parties do not create any external indication. The parties do not create or provide an external indication through any of the previous three modes. This is a situation where the parties straight away act. The parties straight away act as if there is a contract between them already. You see? As if there is a contract between them already. There is no offer or acceptance involved in any other mode as we discussed. So we shall look at what exactly this is and how can such a situation be categorized under contracts. Well, in Arabic, this is called ta'ati or mu'ata, which literally means giving to each other or mutually giving. This is the meaning of ta'ati or mu'ata. In English, you can translate this as contracting through actual exchange. Contracting through actual exchange. We define this as contract based on actions that are indicative of mutual assent. Contracts based on actions that are indicative of mutual assent or mutual consent without there being offer or acceptance. Without there being offer or acceptance. Well, so here the parties act in a certain way, and these actions themselves can be indicative of there being contractors and that these actions having arisen out of a contract, although they did not say so, although they did not utter or express so. But the actions are what the actions of contractors supposed to be. Well, now, I usually draw a lot here, but since we cannot draw properly, I'll try to. You see, now you see before the normal process of a contract. Can you see the screen, blank screen?
Yes, sir.
Yes.
Okay, so normal process of contracting is you see, so there is people discuss, negotiate, and everything happens. And then comes the stage of creating the contract, where the parties actually express their contractual intent. You see, this is the previous diagram I had given you, if you remember. The parties actually make definitive statements. You see, whether they sign papers, in which case they will be signing on the same documents, or exchange documents, or exchange the contractual expression, create the contractual expression individually. So the stage of creating the contract, hereby this contract is created. You see? So the offer and acceptance or the contractual expressions are created through an acceptable mode, such as verbal expression, expression through writing, or expression through signals. This expression of contractual intent is provided. You see? Now, this is the normal process of how a contract takes place or should take place. Now, merely because this expression took place, it doesn't mean there is a contract. There are conditions and requirements to be fulfilled. Once the requirements are fulfilled, some of which we shall discuss next, then upon the conjunction or coming together of these expressions, now the contract is created. You see? Well, you see, actually, everything clear above board, okay, contract created, and now the legal effect takes place. You see? So which can be on the subject matter, okay, let's say it's a sale, let's say goods and price. You see? So the legal effect is reflected on the subject matter and results in the creation of obligations and rights and legal effects such as transfer of ownership. Well, now what we are talking about under contracting through actual exchange is all of this is missing. There is no negotiation or no creation of expressions, no creation of legal effect, nothing. It is only that the parties this is supposed to be a hand, okay? The parties actually exchange you see? This is only what happens. This exchange takes place. This exchange, if in a normal, the normal process of contracting, this should have happened after all these stages. The contract expressions created, expressions come together to form the contract. When the requirements are fulfilled, then legal effect is created, and through the creation of the contract and legal effects, now the parties become obliged with certain obligations. If it's a seller becomes obliged to hand over the subject matter or the goods, and if it's a sale, the buyer becomes obliged to hand over or submit the price. So these actions arising or should arise through a contract that had happened before. But here, nothing happens. All these stages are missing, and the parties straight away act. One party submits, the other party too submits, and these actions are understood to be a contract, despite of the expression being absent. There was no expression. No one said that he is selling or buying. No one said he is creating a contract. There was no expression, no creation of legal effect, no creation of rights and obligations, no obligation on him to submit, no obligation on this party to submit. But they straight away acting in this manner. So now we have to see whether these actions are indicative of a contract or not. And if so, what contract? So what is the basic purpose of the requirement for expression? Why should there be expression? So that the contractual intent is indicated in an unambiguous and clear manner. The vital and significant need fulfilled by expression is that it indicates contractual intent clearly in unambiguous terms, so that the parties themselves and all other relevant parties come to know of the nature of the contract they create. But here there is no expression. The parties do not express at all. They straight away act. So now, do these actions represent contracts? If so, what contract? Let's say that this party who handed over this action, this party who handed over this asset. You see? This party who handed over this asset, now, is he handing over this asset as a seller who is transferring ownership, or is he merely transferring custody? Is he lending this? Is he renting this so that for the other party to use and return? You see? Or is he giving a gift so that the other party can take it and go away and need not give anything back? You see? So this whole action is ambiguous. And the party, if he is actually giving money, what does it mean? Is he giving this money as price for what the other party had submitted? Or is he lending this money to the other party? Or is he gifting this money to the other party? You see? So he's not saying. This is the confusion that should have been removed through expression. The parties should have mentioned, this is what we are doing and this is the nature of the legal effect we are creating. Since the parties did not express, now, can this exchange by itself indicate a contract? And if so, which contract? Well, so you can see now, this situation is not what is supposed to happen in contracts. Contract is creating legal effect through expression, and everything that happens afterwards is based on the previous creation of the contract. Legal effects, rights, obligations, submissions, transfers, all those happen to be results of a contract, and they are not contracts in themselves. So in this situation, when the parties act, based on this action, can we say, although there was no proper expression, that there is a contract or not? So you can see that we cannot universally accept, you cannot universally uphold in every situation that the contracts can take place this way, because this can give rise to a huge amount of dispute and ambiguity. So because of this, in schools of Islamic law, there are restrictions on contracting in this manner. So these creating a contract in this manner is upheld as valid in limited situations. In limited situations, the purpose being the proper expression of contractual intent is the acceptable and proper means of creating contracts, which has its numerous objectives and benefits. Well, so in schools of Islamic law, the exact scope for the validity of contracts created in this manner, the scope varies. As far as I know, the narrow scope is in the Shafi'i school. In the Shafi'i school of Islamic law, creation of contracts through exchange is only possible in contracts of exchange. Contracts of exchange means contracts of sale and contracts of lease and rent in some forms, where there is submission and receipt from both sides. Only in the domain of contracts of exchange or muawadat is ta'ati or mu'at acceptable in the Shafi'i school, because it is in these contracts that at least we can understand through the actions of these parties clearly, without ambiguity, at least to a certain extent, that they are creating a contract. And this must be supported by custom as well, meaning the people in that locality, that area should understand by looking at these actions, they are hereby creating such and such a contract. They should know, people should know that this is a contract. And you should find out more details about this, about the exact position of the schools of Islamic law. But briefly, well, in the Hanafi and the Hanbali schools, speaking briefly, the scope of acceptance of Ta'ati and Mu'ata in these two schools is somewhat wider, because they don't confine the possibility of creating contracts through Ta'ati to Muawadat, to contracts of exchange only. They keep it general. They say all contracts can be created through Ta'ati and Mu'ata, but the requirement is it should be customary, meaning the parties and others understand that these through actions they are creating a contract. This action is indicative of such and such a contract, whatever it is. It should be known. There shouldn't be any ambiguity about the consideration or price, and so it must be customarily upheld, because the custom replaces the indication provided by proper expression. When the people happen to know that these actions represent such and such a contract, there shouldn't be actually a bar to creating a contract in this situation. In the Maliki school, the acceptance of creating contracts in this manner based on exchange is based on the evidence of mutual consent, meaning the exchange at the point of this exchange or creation of this contract should be very clear that the parties are willingly creating the contract of a particular nature through these means. As far as we know of the Maliki school, being upheld by custom is not a strict requirement, but if the willingness and consent of the parties are beyond doubt and evident that they're happy with contracting in this manner, and they understand the purpose of the contract, then the contract will be upheld as valid and permissible. Well, now this is the scope for acceptance of these contracts in general. The restriction being that they cannot be used universally because of they're not being expressive as proper forms of expression. But all the schools of Islamic law agree that Ta'ati or Mu'ata cannot be used in a particular contract, which is marriage. In the contract of marriage, no Ta'ati possible, no Mu'ata possible. You cannot create a contract of marriage based on action alone. There must be expression. And not only expression must be in the most positive and strongest manner. Indication of contractual intent must be evidenced through expression in the strongest mode, which is speech. We said speech provides the most direct and is the strongest means of indication of contractual intent. So speech must be used in a contract of marriage as long as the parties are capable of speech. The reason being, there is a special contract, a sacred contract, and which results in the permanent results, and also to prevent this the lady concerned from being treated lightly. There should be a proper contract in the contract of marriage, And because of the sacred and special nature of this contract, the Sharia requires witnesses. Witnesses are mandatory in the contract of marriage, and the witnesses can bear witness only if they hear the parties uttering and creating the contract. So that too requires creation of this contract through speech. So remember very well that creation of marriage is not possible through action alone. But as far as certain other contracts are concerned, they can be valid based on the scope that we discussed, that they can be created through contracts based on action or mu'ata. Well, so this is a very brief explanation. Please go through your material and easy find out more about the exact nature of this contracting through action, and the scope as discussed in the schools of Islamic law, and the purpose why the scope for the acceptance of ta'ati is restricted in this manner. Why cannot it be acceptable universally in all forms of contracts? Well, so this was a brief explanation about the modes of modes of expression. Now we shall go to the fundamental requirements for expression, conditions for siga or requirements for siga. As we said, the most fundamental requirements which are common to all contracts. When you go to specific contracts, specific contracts have their own details. What should the offer be? What should it contain? What are the conditions in sale? In fact, every type of sale has its own requirements for siga. But our purpose is here to discuss the general requirements for siga so that it can result in a contract. These are in fact three, which are clarity of indication and the acceptance conforming to the offer and continuity between offer and acceptance. So we shall look at these fundamental requirements in our coming lessons. Well, now I hope that you have formed the groups for assignments. Please let me know the topics you have chosen. The topics should be related to what is given in the course outline, but not from the course outline. For instance, you cannot take ta'ati as a topic. Not possible. You cannot take modes of expression as a topic. So choose any issue or any topic related to what is mentioned in the course outline. It need not be what we have studied so far. It can be from the whole course outline. Look at the course outline carefully and choose something related to it, but not directly from the course outline, and the rest of the guidelines are given in the course outline as well as at the end of the course outline. You will see some instructions and also in the guidelines. So before